Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Thank you, Ms. Lindsay. And on behalf of Judges Bennett and McBrayer, we welcome counsel to this oral argument, which we are conducting via Zoom, but more importantly, we are live streaming to the public to maintain our obligation to hold open courts. The proceeding will be held in the same manner as if we were all in the courtroom, together, and each of you has 15 minutes, and I understand the appellant has reserved some time for rebuttal. Unless there are any announcements, I will ask Ms. Lindsay to call the case.
Re Trinity P.
Very good, Ms. Wilson. You have the floor.
Do you mean Miss Venuti?
Excuse me, Miss Venuti, my sincere apologies.
That's okay.
My vision is failing me this morning.
That is perfectly all right. My name is Miranda Venuti. I am the appellant pro se in regards to Trinity Pearson. I would like to start by thanking you guys for hearing my case today. I'm here today to ask your honors to determine if the trial court erred in making their decision to grant grandparent rights to the appellees, Mr. and Mrs. Wilson, under Tennessee Code annotated 366306, and also to decide if the trial court erred in prohibiting me from disciplining my child in the form of spanking under the 14th Amendment to the United States Constitution and Article 1, Section 8 of the Tennessee Constitution. The Tennessee Supreme Court has recently clarified the intent of the legislature while using the terms "is opposed by," places a threshold burden of proof of opposition onto the grandparents in such grandparent right matters. It does not allow for the grandparents or their counsel in these matters to use the testimony of the mother at the trial court as a substitution for opposition. Excuse me.
That's quite all right. Take your time. I know this is a unique experience.
Yes, sir. Absolutely. Case law from the Nashville Court of Appeals, Uselton v. Walton, and Holes v. Alford were both to find the same thing that we face here today. The trial court Uselton v. Walton and Holes v. Alford heard in this case, in this courtroom, they both found that grandparent visitation had not been opposed. And in order for Tennessee Code 366306 to be implicated, opposition must be proven. As you can see by the trial court record, the appellees in this case did not have a single shred of evidence that they were meeting opposition prior to filing their petition for not just grandparent visitation, but for custody of my child. However, in the trial court record, Mr. and Mrs. Wilson both testified that I was a good mother and they had no reason to believe that my child was in any danger. And if this were the case, why would they sue me for custody? Also, Mr. Wilson states that he was under the impression that the relationship between themselves and myself was fine, that we were in great standing. But if that were the case, again, why sue me for visitation? How could anyone believe that if the relationship between us were okay, how could they be meeting opposition?
Well, Miss Venuti, can't you have a good relationship on many factors of one's life, but a parent still say, I'm opposed to you visiting my child, or I'm going to impose significant hurdles or conditions upon which you visit my child. Isn't that possible?
That's absolutely possible. But as you can see in the case or in the trial court record, there was no proof that I had opposed any visitation. Isn't
So
the
did
hurdle of
you-
36? I'm sorry, go ahead.
Did you put some restrictions on visitation though, like that it had to be supervised in some fashion?
Absolutely not. Not until the trial court record when the judge asked me if there were any stipulations. And at that point, I stated with supervised visitations, I would be okay with. And it's because of a violent incident that took place that made me want to leave and distance myself from that relationship. And in doing so,
So had any visitation between the Wilsons and your child taken place between that violent incident and the following the petition?
yes, sir.
Okay.
May 15th to May 16th, I allowed visitation. And only 38 days from that violent incident that occurred to the filing of the petition took place. Only 38 days. However, the statute reads 90 days needs to elapse. And again, there was no proof of opposition in the trial court record.
Now,
Not an email, a text message, nothing.
it's my understanding that you did not have a violent incident or altercation, but Mr. Blizzard
That
and
is not correct. That is only partially correct.
so you were involved as well with Mr. Blizzard and the stepsister?
Yes, my stepsister attacked me initially, and that is in the trial court record as well. And
Okay.
Jessica White, she was arrested for assault on me for that incident. Mr. Blizzard didn't come forward in the incident until after we had been, there were 3 other people that attacked us. There was a total of 4 people that attacked us before Mr. Blizzard stepped in and defended me and my child. My child was present. She watched me get beaten by my stepsister on Mother's Day. Multiple times. I took several blows to the face, the chest. She broke my nose. And my child watched.
But what you're saying is prior to that incident, you had indicated no opposition of any kind or limitation to your mother having visitation with your daughter.
That is correct. I did not state that I did not want a relationship until after I was sued for custody of my child with absolutely no merit.
But to clarify, did you impose limitations or conditions or require supervision?
Not prior to the filing. No, sir.
Okay. All right. Thank you.
Excuse me.
That's quite all right. We've got time.
Tennessee Code Annotated 366306A provides biological parents the protection when it comes to when it can be shown that the biological parent had a reasonable belief that harm would come to the child if the grandparent-grandchild relationship were to continue. At trial, both appellees testified that the grandmother participated in an attack against me, which involved a baseball bat. And the mother, myself, also testified that the grandmother not only wielded a baseball bat, but made contact with the baseball bat when she swung it. She hit me in the arm. My understanding of the 14th Amendment to the Constitution and Article 1, Section 8 of the Tennessee Constitution, I have the right, the fundamental right to decide the care, the custody, and the control of my child. In that incident, I felt that the safety of my child in that home, or in that, what's the word I'm looking for? That environment was no longer safe. So I sought refuge at another location. That right there would prove a reasonable reduction in the relationship due to the fact that proximity had changed. We no longer lived on a common ground. At the day of the incident, we lived at a common address with different residents. After that incident took place, I had to remove myself and my child from the possibility of something bad happening to either one of us. And in doing so, we no longer live 10 feet from each other. Therefore, a reasonable reduction in a relationship could occur. But I never opposed visitation. I never told them that they couldn't see my child. They never asked to see my child. There was no proof. And in order for 36-6-306 to be implicated in the state of Tennessee, the burden of proof of opposition rests on the grandparents in these matters. And the trial court is simply devoid of any evidence of that. I don't understand how a counsel on the other side could make the statement that they use negative inference to make the decision to continue visitation about a man, Mr. Blizzard, whom was accused but never charged of something. And I'm sorry, never convicted of a crime. However, Mrs. Wilson was on the stand and admitted to poisoning an ex-husband, to beating somebody, but previously joking of stabbing the man and shooting a gun at her own child. And then when someone called to question her later about it, admitted that she had the intentions of shooting him. But a negative inference of a man who was accused but never convicted of an aggravated assault, negative inference, it doesn't relate.
All right, Ms. Venuti, thank you for your presentation. You will have additional time to respond after we hear from the appellee.
Yes, sir. Thank you.
The floor is yours, Ms. Boudreau.
Thank you. Good morning, and may it please the court. I'm Debbie Zimmerly Boudreau of the Law Office of David McKenzie down here in the 17th Judicial District. I'm here today on behalf of the appellees, the petitioner grandparents, Jamie and Brian Wilson. The grandparents visitation statute was enacted, I believe, back in 1971 because lawmakers saw fit to protect the substantial relationship and the important relationship that exists between grandparents and grandchildren. It's been amended several times since that time to respect the privacy rights and decision-making authority of good parents while also balancing the interests that a child has in that significant relationship with her grandparents. And this right only exists in limited circumstances. Not every grandparent is entitled to act under this law. So for example, a grandparent of a child whose parents are still married and who's never lived with her grandparents, those grandparents are not entitled to act under the statute. In the case at hand, the court relied upon the fifth category. There are 6 categories under which a grandparent can bring this cause of action. And they must prove that there has been either a cessation of contact or severe reduction of the visitation. And in this matter, Judge Bassard, the lower court, relied upon the 5th category, that the child resided in the home of the grandparents for a period of 12 months or more, and that she was subsequently removed by the parent. Severe reduction has been defined in the statute to mean reduction to no contact or to token contact, as defined in the code at 36-1-102. And token contact means that the visitation, under the circumstances of the individual case, constitutes nothing more than perfunctory visits of such an infrequent nature or of such short duration as to merely establish minimal contact. That's a lot, but said another way, token contact is to be considered under a case-by-case basis, taking into consideration the existing contact the child and the grandparents had prior to the cessation and the severity of the new limitation that's been imposed by the parent. Next, they must prove a substantial harm to the child, and this may be upon the cessation of the relationship, and that cessation of that relationship would be harmful to the child. Under Factor 5, which the court relied upon in this case, the type of relationship that exists in this matter establishes a rebuttable presumption that denial of visitation may result in irreparable harm to the child. And once those are proven, the court can then move on to a best interest analysis. This record is an interesting read for certain. And though Ms. Venuti and I will likely disagree on the high points and which facts the court should have given more weight to, that simply does not matter. What does matter is that great weight is given to the trial court when considering how to weigh that evidence. There is a presumption of correctness as to the findings of fact in this matter. As outlined in our brief, a determination of visitation often hinges upon subtle factors such as the party's demeanor and credibility during the trial proceedings. When credibility and weight are to be given when testimony is involved, considerable deference must be afforded to the trial court when the trial judge had that opportunity to observe the witness's demeanor and to hear in-court testimony. Much of Ms. Venuti's brief and her argument today focuses on what she feels is a misapplication of the facts. Most of her argument relies upon why she feels her personal impression of the events that led to the cessation of contact are more persuasive than the facts that were presented by the petitioners. But the court in this case gave weight where it was due. The lower court had the opportunity to observe these witnesses, and though much can be inferred from the record or read between the lines, so to speak, the lower court's impression of those witnesses and their testimony is to be given considerable deferences. Beyond that, I'd like to address two of the points that Ms. Venuti raises. First, whether my clients were actually deprived contact with Trinity, and second of all, whether the court erred in eliminating corporal punishment and depriving the parties of making derogatory comments in the presence of the child. The mother claims in her brief that the plaintiffs have failed to prove a cessation of visitation. This claim she makes to show that they do not have standing to bring this action, but the statute, as stated above, does not require complete deprivation of contact. It requires that the parent either oppose or severely reduce the grandparent's visitation. And the Supreme Court defined opposition as including situations both where visitation is denied totally and where it's technically not opposed, but the frequency or conditions imposed by the parents are such that it equates to a denial of visitation. And this is outlined in the Halls v. Alford case. This case came out, I believe, prior to the statutory change, which clarified there need not be complete cessation, but the spirit of the case and the law are clear. The statute went on later to add severe reduction and to define that, as previously discussed, as being token in nature. It's undisputed that Trinity had resided with the grandparents for more than a year straight prior to the cessation of the contact. And it's also disputed that off and on throughout her short lifetime, she's lived with the grandparents more than half of her life. Less than 1 week after the altercation on Mother's Day, the record shows there was one overnight visit. That was the last time the grandparents were permitted to see Trinity. The grandparents did not bring this action until more than a month later. For a child who
Are you suggesting that they asked or sought visitation during that period and were denied?
Your Honor, I don't have the pages memorized as far as the technical record goes and where the grandparents testified about their contact with the mother. The mother moved out of the home after the incident when her boyfriend was arrested for the aggravated assault charges. And after that point, I believe the record shows that the grandparents did have contact with her, that the mother came back to the house several times to pick up things, but that she didn't bring the child. She brought the child one other time, 1 week after the incident that led to the cessation. I believe that was May the 15th for an overnight visit. But during those times that she came back to the house to pick up items, she did not bring the minor child.
Well, but did the grandparents seek more visits with the child? What does the record say?
Yes, sir. They were in contact with the mother. And again, as far as the technical record goes, I can't recall exactly where the grandparents, if it was the grandmother or grandfather, that stated that they had attempted to make that contact.
If you say they attempted to make that contact, do you mean to phone call the daughter or a request to see the grandchild? What type of attempts to contact and what was
I believe there were phone calls with the mother.
But they were not answered?
The mother and the grandparents did speak because the mother was attempting to come over to obtain her items from the residence. She mentioned that there are 2 residences. I believe the record shows that there was a camper on the property and there was a house. The child would occasionally stay in the camper with her mother when she was not working, and she would stay in the house when she was. So this family has lived together for years, and the mother had to come back to the house to obtain her items. And during those times, she did not bring the child with her to visit with the grandparents, who saw the child every day prior to the cessation of the contact. The only visitation, the record shows that the only visit that the grandparents were permitted to have was that overnight visit on the 15th and the 16th. And they did not bring this action until more than a month after that cessation.
But other than that one visit, to follow up on Judge Bennett's question, what efforts did the grandparents make to visit the grandchild, and what opposition did the mother raise?
Your Honor, I'm not certain if that's in the record.
Okay, thank you.
Yes, sir. For a child, I think it's important to note, though, for a child who sees her grandparents daily, as Trinity did, as opposed to a child who only sees their grandparents once a month, as some grandchildren are only allowed to do, this does constitute a severe reduction of their traditional contact. And as the statute provides, under the circumstances of this particular case, my clients were reduced to token visitation prior to bringing this petition. Now, the mother relies on the whole.
Are you suggesting that the mother should have brought the child voluntarily to the grandparents?
Your Honor, this child was used to or had.
That doesn't answer my question. What was mother's obligation? Was mother obligated to bring this child to the grandparents every time she came to pick up an item?
No, sir. I don't think she was obligated to do anything.
Well, that seems to be what you were saying, because you kept saying mother never brought the child when mother came to get things. Mother wasn't under an obligation to bring the child, was she?
No, there was no order that required the mother to do anything. No, sir.
Okay.
And I think that that's the purpose of the statute, is when a parent does reduce or limit that contact, we have a statute to address that. And because she no longer permitted that child to see grandparents who saw the child every day, that is a severe reduction of her time. The mother relies on the Halls case to support the position that the petitioners failed to prove deprivation, that would be enough to reverse the lower court. However, in the Halls case, the respondent parents both specifically denied at trial that they wanted to deprive the grandparents of contact. In this case at hand, the mother testified specifically that she did oppose visitation, and that she wanted, and that if the court were going to order any type of visitation, that she would want that to be supervised. That testimony that she did in fact oppose visitation, coupled with the severe reduction, if not cessation, of the parties' relationship prior to the petition being filed, is proof positive of her intent. I do want to briefly address, I've got a few minutes left, I want to briefly address mother's concerns that the court has eliminated the parties' ability to corporally punish the child, which she's addressed here orally today. But she also addresses in her brief that she takes issue with the lower court eliminating the parties' rights to speak derogatorily about one another in the presence of the child. Mother testified on page 169 of the transcript that grandmother was a good grandmother when, according to mother, violence and anger were not an issue. Mother testifies repeatedly that violence is a concern to her, hitting is a concern to her, and that the anger and language are a concern to her. The court, when issuing these restraints on the parties, was simply reacting to concerns that the mother herself raised for the child. These are reasonable safeguards that are often ordered by courts in divorce and child custody disputes. In fact, our parenting plans, at the very top of the first page of a parenting plan, specifically eliminates the opportunity for parties to speak derogatorily about the children in the presence of the other party. This child need not suffer the ill will of the adults in her life. She's loved by many people, and that love should not be clouded by negative impressions that adults hold for one another. Your Honors, the lower court did an excellent job in applying the facts to the law of this case. Again, I ask you to give considerable weight and deference to the lower court's findings of fact. The technical record is replete with a lot of, I guess, drama is the only way to really say it, on many parties' part, but the court did a very good job in weighing that evidence appropriately, and therefore we ask the court to uphold the lower court's order in full.
Ms. Boudreau, let me ask I certainly applaud any court that says that the parents and grandparents shouldn't speak badly of others in front of a child. That's common sense, good parenting. caring, loving thing to do. But in the matter of law, how does that issue or right come into play in a grandparent visitation action? The due process requires notice that there be a claim and a legal right that's presented and at issue. And although there was testimony about, everybody loves each other, nobody should be hurt, what have you, how does the corporal punishment order come into play in this case?
And Your Honor, it's not something that I think either party raised at trial. This was something that the court kind of sua sponte ordered. And I think that was based upon the mother's concerns about hitting, how the grandmother might pop the child on the behind with a spatula in the kitchen. The mother, my recollection is the mother testified at one point that she had popped the child, I think were her words, and she actually apologized to the court about that. I think the court was probably concerned based on the history that was presented that day about violence in the home and was likely acting to protect this child from any future violence. But I understand your point. If there was no notice given to either party that this was going to be raised, I certainly understand that. I think this was the lower court probably trying to put some of these issues at rest and to know that this child wasn't going to suffer at the hands of either the parties or third parties who might attempt to corporally punish this child.
All right, thank you. And I applaud the trial court for wanting to protect the child and impose good common sense. That's a wonderful thing. All right, anything further?
No, Your Honor. Thank you.
All right, thank you. Ms. Venuti, you have your time for rebuttal.
Unmute, please. There.
The Tennessee Supreme Court cited Uselton v. Walton recently, stating that the argument that post-petition opposition to visitation arguments fail because Tennessee Code Annotated Section 366306 requires evidence of parental opposition when the petition is filed and requires evidence of existing opposition, not future opposition. The state of Tennessee trusts the instincts of a fit biological parent. Therefore, if I choose to remove my child from a violent situation, I should have such right. The statute that a counsel brings up says that 12 months, the child lived with the grandparents 12 months prior to the cessation of a relationship. It actually states immediately preceding. The 12 months immediately preceding the cessation, or in my case, the reduction in relationship, was not, we didn't live in the home with the grandparents. We had a common address and separate dwellings. We did not live together. The statute states immediately preceding. In our case, that is not the case. And it also states that the child was removed from that grandparent-grandchild relationship for reasons other than the risk of substantial harm to the child. Okay, I don't have other than risk of substantial harm. I have risk of substantial harm. I was attacked with a baseball bat. 2 members of the household had baseball bats. I was struck by one, the grandmother in this case, and 2 other members of the household attacked me on Mother's Day in front of my child while I was at my residence in a camper on their property, minding my own business, doing my own thing, and I was attacked violently. As Your Honors, you brought it up. It's not my responsibility to call them and ask them, hey, do you want to see my kid this week? Would you like visitation this month? That's not my responsibility. As a fit biological mother, that is not my job. My job is to take care of my child, feed her, educate her, raise her to be a strong, independent person. I should not have to call my mother, call my stepfather. Would you like to see Trinity today? That is their responsibility. Proof of opposition, the threshold proof of opposition relies on them, not on me. Counsel's argument here today is simply a straw manning argument. Sure, some of the things parallel certain cases, but the bottom line is, in order for, as the Tennessee Supreme Court and the United States Supreme Court have stated, in order for Tennessee Code Annotated Section 366306 to be implicated, the grandparents must be opposed by the custodial parent. We do not have opposition in this case prior to the filing. And in order to get to the issue of safety under 366306B, proof of opposition must take place prior to the filing of a petition. And again, in order to get to Tennessee Code Annotated Section 366306C, which is the, excuse me.
Yeah, take a deep breath. You're just fine. You might be surprised that lawyers even have to catch their breath during.
I believe it. I believe it. This is a pretty emotional situation. In order for the courts to reach potential harm or safety, the best interest of the child, I apologize, that's 366306C. In order for them to get to C or to get to B, they have to prove opposition. And I apologize, but as the trial court record shows, Miss Debbie Zimmerly is not correct. She cannot recall a section in the trial court order, or I'm sorry, in the trial court record of where they asked for visitation and I opposed. She cannot recall it because it is simply not there. They did not bring text message, email, phone call, any record that they had tried to contact me to see my child and that I opposed that contact. Thank you for hearing my argument today, sirs.
All right. Thank you, Ms. Venuti and Ms. Boudreau. You have both given us a lot to think about. Ms. Venuti, since you're not familiar with the process, what the panel will do is we will take this matter under advisement. The three judges will discuss it, and then one of us will be assigned the responsibility to author a written opinion, and that written opinion will be filed with the clerk of the court, and it will be mailed to you and the opposing counsel and made available to the public.
Yes,
all right, that concludes this case. Ms. Lindsay.
thank you, Your Honors.
This Honorable Court of Appeals stands in recess until 11 a.m.
Thank you.
Thank you, and you're free to leave the meeting.